Hi, everybody. This is David O'Day with O'Day Schneider PLLC, and today we're talking about free speech in the military, a landscape that's very different from civilian life. The First Amendment doesn't disappear when someone puts on the uniform, but it operates under unique constraints. Let's start with Parker v. Levy, a Supreme Court case. During the Vietnam era, Army Doctor Howard Levy publicly encouraged soldiers to refuse deployment and disobey lawful orders. The Supreme Court held that the military is a specialized society governed by its own rules, where certain restrictions on speech are not only permissible but essential. Levy's statements directly undermined the chain of command and mission readiness, so the court gave deference to Congress and military authorities in restricting such speech. The key point: speech that strikes at the heart of discipline, readiness, or obedience to orders isn't protected under the First Amendment in the military context. You see the logic of this in the Uniform Code of Military Justice and the contemptuous word provision, which makes an offense to use contemptuous language against senior officials. The rationale is simple: eroding respect for the chain of command weakens military effectiveness, and courts generally uphold Congress's judgment on what speech is detrimental. But then comes United States versus Wilcox many years later, a Court of Appeals of Armed Forces case, and it adds to the complexity. Wilcox was a soldier who posted extremist and offensive political views online, and the government charged him under Article 134, arguing his speech was prejudicial to good order and discipline. However, in that case, the court found no evidence that his comments actually harmed unit cohesion or military function. The takeaway: not all offensive or extremist speech automatically destroys discipline. If the government can't prove tangible harm, the speech may be protected. Wilcox shows there's a small but meaningful space for core political expression, especially when it's not directed at superiors or interfering with the mission. The government must prove real harm, just not speculate. Finally, in Larrabee versus Del Toro, a DC Circuit case raises a different issue: jurisdiction. And that case asks whether a retired Marine in the Fleet Marine Corps Reserve could be court martialed for crimes committed after leaving active duty. And the court said yes. Congress can constitutionally extend UCM jurisdiction to retirees who still receive pay and remain subject to recall. So while Larrabee isn't a First Amendment case, it matters because it defines who's still inside the system where military speech restrictions apply. In theory, retirees could be punished for certain speech, but practically, the government's interest is much weaker since retirees are far removed from the chain of command. So, across these cases, Levy, Wilcox, and Larrabee, a spectrum emerges. Levy draws a hard line around unprotected speech that undermines readiness or authority. Wilcox recognizes a narrow zone for protected political expression when there's no proven harm. And Larrabee reminds us that even retirees may technically fall under military law, but their speech is probably less likely to justify restrictions. The thread connecting all of this is context. In the military, speech is judged by its effects on discipline, cohesion, and the mission. That's the trade off for serving in a system built on command and obedience. But even within that system, the Constitution still has a voice, protecting conscience and political thought, even if it's quieter than civilian life. Thanks for watching the video.